Hello, my name is Alysha Kinchloe. I'm an attorney based out of Philadelphia, Pennsylvania, with a practice called Kinchloe Law, where we dedicate our practice to providing information and solutions and knowledge to our community. I decided to choose family law because it's not only a heartbreaking and contentious area to practice, but it's one where I definitely think that it's necessary for people who care about families and care about the Black community to be into. And also, the family is at the core of who we are as individuals when it comes to the psychological well-being, the economic well-being, and the emotional well-being of our community. Again, that's why I chose that area. And what I dedicate my practice to is providing information. So I also give free workshops, often they are for fathers' rights, to provide information around the areas of divorce, custody, and support. What I want to talk to you today about is 3 parts to considering a custody law issue. That is the law, the process, and the practicality. The first part is the law. The law is going to be the statutes and the case law that your state and your locality will consider when determining a custody law issue. If you're deciding to go at this pro se or with an attorney representative, it's important that you understand the law in your area. For example, in Pennsylvania, the courts will focus on the best interests of the child, not necessarily what the parents want. So it's important that as you're preparing your evidence and preparing your arguments and strategy, that you're thinking about the best interests of the child. In addition to that, the courts will also look at 16+ factors when considering how to award custody. Those factors include the mental well-being of each parent, the sibling relationships of the children. They also will consider, which is actually the first factor, which parent is more likely to encourage contact with the other parent. Now, when you're building your case, you should look at each one of these factors and consider how they would weigh in favor of one parent over the other. And that is something that I do with my clients. I not only ask them, tell me your best argument for each one of the factors, but also tell me the other party's best argument against you. So that helps me to prepare for court and would help you too. You also should consider how the law is going to look at each one of those factors when they're pretty close. So let's say that there's a sibling relationship between your children as well as maybe other half children. How will the court look at that? Does it mean that if there's siblings that the child may be leaving if they go with you, that the court's going to automatically award primary custody to that other parent? That's not necessarily the case. But it's important to look at the case law and how things have been determined in the past to see which way it will go. The next step you should look at when you're considering a custody issue is going to be the process. That's what actually happens, the procedure. You can look to your court's local rules, and often these are your county rules, but you can also talk to an attorney, and you should, about what actually happens from the time that you file your custody complaint until you actually go into the hearing. Who's going to be hearing your case? Will it be a conciliator? Will it be a master? Will it be a judge? That will help you to determine how to prepare. You should also understand what's going to happen when you get into the room. Who's going to be there? What's it going to look like? How long will you actually get to argue your case? That is something that I find that a lot of people aren't prepared for. When they have a hearing before a judge, they think that they can bring in 6 witnesses, some experts, a lot of evidence, but often they're only listed for 45 minutes to hear their entire case. So it's important that you understand what the process and procedure is going to be, so you know if you have to ask for more time, may have to request subpoenas, things of that nature. You should also understand, especially if you're pro se, which means that you're representing yourself, what types of evidence is admissible and what forms is it admissible. One of the things that a lot of people will bring to court with them is going to be text messages, because that's how we communicate now. Sometimes there will be social media posts, and often there are emails. You need to understand what the court rules are when it comes to authenticating this evidence, which means how do you establish that it's complete and that it's true and that it's coming from the person that you say that it's coming from? And how do you move those things into evidence? How many copies should you bring? Are you allowed to actually have recordings of someone? Is it illegal for you to actually record someone? You have to be aware of the wiretapping laws in your jurisdiction. So it's important that you understand the process as you're building your case. And this is something that your representative should speak with you about, as well as when they're speaking to you about the law, because it will help you with your strategy And I think the most important thing it does is to help you manage expectations. So you have a clear idea of what you're going into and what you're fighting for. One of the things I didn't talk about when I talked about the law, but I think is also an important thing, it's going to help me talk about the next area, the final area, is exactly what is custody. Custody is, and in Pennsylvania, there's two forms of custody. There's physical custody and there's legal custody. Legal custody is the right to make certain decisions. These are medical decisions, they're legal decisions, they're decisions about where your child goes to school. Most often, people get shared legal custody when it comes to this, unless you can show that the other parent has some type of severe mental illness or some other issues when it comes to making decisions. The other custody, which is usually the one that we're most talking about, is going to be physical custody. Where is the child going to be and when? And there's different types of custody. There could be something called visitation, which Pennsylvania doesn't have, but a lot of other states do have. Then there's something called primary custody, which people often confuse with sole custody, which means that the other parent has no custody at all of the child. So there's sole, there's primary, and there's partial, and there's something called supervised custody, which is the other parent has to be supervised when seeing the child. So it's important to understand exactly what it is that you ask for. I often see that when people come to me and they file matters on their own, they start off by asking for sole custody, never really wanting that. And what that does is that it sets the other person in a situation, they're fighting against sole custody, not understanding that's not what you want. And again, that's why it's important to understand the law and understand the process. And then finally, the one thing I wanted to talk to you, which I think is the most important, is going to be practicality. What is your custody fight really gaining you? What does it actually look like when you get a custody order? How is it actually going to affect you? How is it going to affect your children? Some people fight for primary custody because they understand what it may mean for a child support obligation. It may mean that they may get more money. It may mean that they can pay less money. But when it actually comes down to whether you can actually be the primary parent for your child, with your work schedule, with your other obligations, it may not be realistic. So it's important to understand that. What is it going to mean to your children to be with you 50-50? Do they want to go between your house and the other house half the time, every other week? As adults, we don't want to do that, but we're willing to sometimes ask that our children do that, just so we can say that we have them half the time. It's important that you sit down and you consider these things as you're making your fight. And any attorney who's going to sit with you should really be doing this with you as well. Unfortunately, I see attorneys who don't do that, and it's about the when. My focus is on the family, because again, that's why I'm here with you today talking with you, is we're looking at building stronger families, understanding that the reality of it is that most people don't stay married any longer, and that a lot of children are not born into wedlock in the first place. So you're already looking at taking maybe a structure that was singular and cutting it into two. But that doesn't mean that we can't have strong families. And that is what my practice is about. And that's what understanding what a custody case means to you from the law, the process, and the practicality should mean to you. If you have any questions about this area of law, which I love talking about, feel free to contact me. Again, my name is Alicia Kinchloe, owner and founder of the Kinchloe Law Firm.